What's up, y'all? AWB, I'm back at it. I'm gonna wait for a couple people to get in the chat, and we'll see. I know it's been a little while since I've done a live stream. Y'all all know what's going on with me. Still recovering. So while we wait for a couple people to jump in here, I just want to say I have my book available on Amazon. The link will be in the description. Y'all go ahead and pick up these books. You know, it's a really good read. You get a lot from it, and you'll help support me. And yeah, so let me share this. But I got a couple very wild videos that we're gonna check out. All right. And, all right, we at the Civil Rights Lawyers channel, and the title of this video: 11 cops busted by one video. Police chief resigns, and that's tell you everything right there.
Or a culture of covering up misconduct.
Where Officer Andrew Basaggio went around to the front of Sean Kastner while two other officers each had a hold of his arms behind him, and Andrew Basaggio delivered two knee strikes.
Blood everywhere. My knee spike busted his face open.
Okay.
Well, I got blood on me. I need something to clean my hands with. All right. I tased him several times.
Taking his knee and putting it in Sean Kastner's face, resulting in trauma to Mr. Kastner's face. He was then tased 7 times in his living room.
To knee spike somebody in the face, it has to reach a level where you feel that your life is in danger. Obviously, that was not at that point. The video is troubling.
Shocked. Absolutely shocked.
It's crazy what's happening with the Kissimmee, Florida Police Department. Here's how things started for their newest police chief in May of 2023, Betty Holland.
The Kissimmee Police Department has announced Holland as their new police chief. Holland says her top priorities include strengthening community relationships and training.
It's my responsibility to ensure they grow and they become, the best person they can be.
And here's how things are going now.
In the last 2 hours, the city of Kissimmee announced it has accepted the resignation of Chief Betty Holland after another Kissimmee police officer was indicted by a grand jury his use of force on a man during an arrest.
Betty Holland has resigned as chief of police after taking over that role in May of 2023.
So body cam footage from this one incident has now led to the resignation of the Kissimmee police chief, Betty Holland, along with 10 other officers who are also under investigation.
Some officers who are still employed with the Kissimmee Police Department were either not forthcoming or outright lied during interviews and testimony before the grand jury.
You are allowed to resist an unlawful arrest. So if somebody's unlawfully in your house, like this particular instance where law enforcement was unlawfully in your home, you're allowed to lawfully resist them without violence, which is what happens.
So what is ClickUp? ClickUp is an all-in-one productivity software. To productivity, organized in a single place.
At a press conference, Florida State Attorney Andrew Bain announced the findings of a grand jury in indictment of Kissimmee police officer Andrew Baseggio.
The grand jury found the Kissimmee Police Department harbored a culture of silence or a culture of covering up misconduct.
Where officer misconduct is not only not reported, but accepted.
To our community, I want you to know that we are committing to restoring and earning your trust daily.
Shocked. Absolutely shocked.
You know, all these things that they found, it's nothing unusual. Stuff like this happens across the country. What's unusual here is the way this has been handled. They are actually cleaning up the situation. I'll show you the body cam footage that triggered all this. It would basically just be a routine video that I cover here on my channel.
So it's one lie, and then you try to cover it up with another lie, and then it just mushrooms into something that we never intended it to be. And that's kind of what happens in the department sometimes. And unfortunately, this is what happened here.
But first, you know how I love these promotional videos that police departments put out. I found this one that the Kissimmee Police Department did a few years ago. So I did them the favor of sprucing it up just a little bit and updating it. Check it out.
What we're looking for when we recruit an officer to the Kissimmee Police Department is, our integrity, our honor. That is the cornerstone of what we do in law enforcement.
We promote teamwork.
We value dignity.
We strive to do everything that we can to serve the community and do it in the right way.
It's very important for us to shed a positive light to let the public know that we're still humans and we are all in this together.
Everything centers around building relationships in our organization. So that's not only inside the building, but our dealings with the community.
Jesse, in the last 2 hours, the city of Kissimmee announced it has accepted the resignation of Chief Betty Holland. This decision comes after the state attorney's office sent the city a letter raising concerns about her credibility and the credibility of others within the department. After another Kissimmee police officer was indicted by a grand jury, his use of force on a man during an arrest.
The police chief and deputy chief resigned. Other officers are on administrative leave. 11 are targeted for investigations.
The issues the grand jury and the state attorney's office identified are deeply troubling.
Raising deep concerns as to the issues about systematic practices within the Kissimmee Police Department.
Body-worn camera footage showed the involved officers laughing about the incident.
I get out of my car. I talk to people. I feel like community involvement is probably one of the top.
I don't know if y'all hear that music in the background, but I think this is hilarious, really.
Things every agency should be thinking about. You need to know who you're serving. They need to understand where you're coming from.
Well, if you could sum up the grand jury's take on the Kissimmee Police Department, you could say it's a mess for a number of reasons, including lack of integrity for some staff members, lack of training, and scariest of all, a code of silence that allegedly allowed Officer Andrew Baseggio to basically get away with beating a man.
When we say family, we really mean family. We treat each other like that. We want everybody to feel like they are welcomed, like they're included.
I will give you the same challenge I give to anybody in our community.
The grand jury found this culture of non-reporting extended to Baseggio's punishment, which was limited to a single day off without pay, and labeled merely as a, quote, failure to obey policies, thus avoiding mandatory reporting to the Criminal Justice Standards and Training Commission, the agency responsible for maintaining ethical standards in law enforcement.
Come give the Kissimmee Police Department a chance, and you'll see what's in our heart. Come visit us, come right along with our officers, I promise you, you want to be a member of our organization.
Big Pharma hates when you do this, but they can't do a damn thing about it. These shoes help relieve back pain and knee pain, making you feel like you're walking on clouds. They're already been sold out multiple times on Amazon and Walmart and all those other big box stores because it's been a top recommendation from pain specialists. And now the company behind it is cutting out the middlemen after selling over 2 million units in the last 9.
Today, we are here to share the grand jury's findings and recommendations for the use of force involving Kissimmee police officer Andrew Passaggio.
During a press conference last week, Florida State Attorney Andrew Bain announced the findings of the grand jury following this misconduct investigation and indictment of Kissimmee police officer Andrew Passaggio. This investigation came after Officer Passaggio was accused of attacking a man inside his home while other police officers allegedly covered it up in August of 2024.
In August, the Osceola County grand jury indicted Officer Passaggio on 6 charges. One of them being felony battery, 2 counts of tampering with a witness, official misconduct, solicitation of perjury, and misdemeanor battery. These charges stem from an incident that happened in 2023, and with a 911 call resulted in Officer Passaggio's knee spiking a man in the face, causing serious injury.
The body cam footage shows a struggle between Sean Kastner and his father outside their home.
No, get out and shut the door. No, I'm not coming out.
Officers then entered the residence.
No, get out and shut the door.
But then the video cuts to black. And what happens next inside that home prompted this prosecutor's office to open a use of force investigation, and that was in April of 2023, just 1 month after the new police chief came into Kissimmee.
I didn't threaten anybody's life. I didn't want to hurt myself. I'm not going to Parkland.
He is okay.
This is harassment.
Facial injuries.
I'll calm down. You can't banker after me because I'm not suicidal against myself. I didn't threaten anybody's life, and I'm asking you nicely, can you take the cuffs off? I didn't do anything. You can't have me in cuffs right now because I didn't do anything wrong. I didn't fight you. I did not. He tried to make it look like I pushed him. He's trying to get me in trouble.
One officer on the scene described the incident saying, "We went hands-on to arrest him, and he's sweaty. He has no shirt on. We got him pinned against the couch right there. He kept fighting, so I gave him a couple of knee spikes to the face. Good ones. Split his face open. He got blood everywhere."
Multiple uses of force? Okay. My knee spike, there's blood everywhere. My knee spike busted his face open.
Okay.
Well, I got blood on me. I need something to clean my hands with. All right. Okay. I tased him several times.
The officer added that he used a taser on Kastner, who was later arrested with visible injuries, including blood on his face and something lodged in his back. The incident triggered an internal investigation into honesty within that police department. On October 21st, State Attorney Andrew Bain's office sent a letter to Kissimmee leadership requesting a formal investigation into allegations of untruthfulness and misconduct by some members of the police department. And it also follows an Osceola County grand jury's findings and recommendations. In the letter, Bain's office said the investigation initially focused on the 2023 use of force case involving Officer Passaggio, who responded to a disturbance and entered a home without a warrant and violated the department's use of force policy to take a man into custody. The grand jury found that the Kissimmee Police Department fosters a culture of silence, where officer misconduct is not only not reported, but it's accepted.
The grand jury found the Kissimmee Police Department harbored a culture of silence or a culture of covering up misconduct.
Evidence and testimony that was presented to the grand jury showed that the officers failed to report Passaggio's excessive use of force, which went on for several minutes without intervention from the 2 other officers on the scene, and the body cam showed the other officers on the scene laughing about the incident.
The grand jury found that the Kissimmee Police Department fosters a culture of silence where officer misconduct is not only not reported, but accepted. Evidence and testimony presented to the grand jury showed officers failed to report Passaggio's excessive use of force, which went on for several minutes without intervention from 2 other officers who was on the scene. Body-worn camera footage showed the involved officers laugh about the incident and intentionally avoiding discussing it on their body-worn camera.
I get out of my car, I talk to people, I
feel like community involvement is probably one of the top things every agency should be thinking about. You need to know who you're serving. They need to understand where you're coming from.
Statements made by other officers at the scene suggest that officers were aware that the use of force that night was excessive, and still they did nothing.
When we say family, we really mean family. We treat each other like that. We want everybody to feel like they are welcomed, like they're included.
The grand jury found this culture of non-reporting extended to Basaggio's punishment, which was limited to a single day off without pay, and labeled merely as a, quote, failure to obey policies, thus avoiding mandatory reporting to the Criminal Justice Standards and Training Commission, the agency responsible for maintaining ethical standards in law enforcement. The grand jury went on to say it lacks confidence in the Kissimmee Police Department's command staff and has requested the city conduct a thorough evaluation of that group.
Everything centers around building relationships in our organization. So that's not only inside the building, but our dealings with the community.
The grand jury found that despite clear evidence of misconduct in Officer Basaggio's use of force incident, that former Chief Holland chose not to criminally investigate the incident initially and failed to report Basaggio's department policy violations to the appropriate agencies, including the Office of the State Attorney.
Well, I mean, Chief Holland did say that it was her top priority, or one of her top priorities, to take care of the police officers under her command so that they too could one day be the chief of police of the Kissimmee Police Department.
Holland says her top priorities include strengthening community relationships and training. She says the most rewarding part will be being able to help those in need and help members of the agency grow.
It's my responsibility to ensure they grow and they become, the best person they can be. And so I think that will be more impactful for me to see, them grow and maybe one day be chief.
The investigation was compromised from the very beginning because Officer Basaggio was able to have access to knowing the investigation was going on, and then began to tamper with other witnesses along that during that time. So then we went back in and interviewed a lot of those witnesses that were inside of that investigation, and it turned out that many of the things that they stated were falsified.
In fact, the state attorney's office only learned about Basaggio's unlawful use of force after watching a news report on TV, after which we repeatedly requested the Kissimmee Police Department request a criminal investigation into the matter. The grand jury determined that when the Kissimmee Police Department finally relented and authorized the Florida Department of Law Enforcement to conduct an investigation, that investigation was compromised from the very start.
What we're looking for when we recruit an officer to the Kissimmee Police Department is, our integrity, our honor. That is the cornerstone of what we do in law enforcement.
Not only did Chief Holland notify Basaggio about the criminal investigation, but he was also shown the final report before prosecutors reviewed it, allowing him to tamper with witnesses.
When asked by the media why the prosecutors thought that police officers would actually lie to cover up the misconduct by one of their colleagues, they really had no idea. I mean, it's just shocking. This has never happened before, has it?
Sean Wiggins, Assistant State Attorney. There's no indication on why they all chose to make the decisions that they made through the course of this investigation. But our investigation consistently came across individuals who are listed in that letter that took actions that we felt warranted notifying the department of their conduct through the course of the investigation.
The grand jury's investigation also highlighted broader issues.
Yeah, I don't want to stop the video too much, but y'all, this is hilarious what they're doing. And yeah, Mitch, they should teach the Constitution. Or what throws me is the oath that they take, and when they do their ceremony, They don't say anything about the Constitution. They say they're gonna protect it, but they don't mention it at all after that. And that's what they're swearing their allegiance to, or they swearing themselves to it.
Issues in the department regarding training deficiencies. Although designated as, quote, critical incident trained, none of the officers on scene in the Basiglio use of force matter recognized the victim was experiencing a mental health crisis. Additionally, officers entering the victim's home were unaware that this warrantless entry violated clear legal standards. The grand jury found that this demonstrates an insufficient understanding of search and seizure laws, and they are calling for enhanced training for all KPD officers in crisis management, search and seizure, and proper investigative procedures. Basiglio's conduct was initially reviewed by a corporal who approved it despite clear wrongdoing. The grand jury concluded that the Kissimmee Police Department also repeatedly failed to comply with Florida law that requires it to report policy violations to the criminal justice.
If you are a husband and wants your wife to fall passionately in love with you again, then this will be the most important video you watch all day. It doesn't take too
Standards and Training Commission.
Come give the Kissimmee Police Department a chance, and you'll see what's in our heart.
The grand jury found approximately 10 instances where sustained policy violations went unreported to the commission and spanned multiple chiefs' administrations. The grand jury discovered a pattern of labeling excessive force incidents as mere policy failures rather than specifying actual misconduct, suggesting possible intent to avoid the mandatory reporting. Reminder that this reporting allows the commission to ensure that law enforcement officers who are disciplined, resign, or are terminated by one agency cannot simply get a job with another agency without the second agency knowing of the wrongdoing. Finally, the grand jury believes the integrity of the Kissimmee Police Department is further undermined by instances of dishonesty during the investigation into Basiglio's use of force. The grand jury found clear evidence indicating that some officers who are still employed with the Kissimmee Police Department were either not forthcoming or outright lied during interviews and testimony before the grand jury, raising serious concerns with the grand jury about the department's credibility.
You know, it's part of the psychology of group thinking, and then you try to, say it's one lie, and then you try to cover it up with another lie, and then it just mushrooms into something that we never intended it to be, and that's kind of what happens in the department sometimes. And unfortunately, this is what happened here. Well, then you have situations where people are being arrested for things that they may not have been arrested, should have been arrested for. People's rights can be violated, like what happened in this particular case. There are a lot of things that can happen in the course of an investigation or in the course of a case that can cause serious problems for multiple people, including the public.
The incident involving Basiglio and everything that sort of sprung from that obviously began in April of 2023. What you'll see discussed in the grand jury presentment is through the state attorney's investigation, audit of past initial or IAs or internal affairs investigations was conducted, and then brought to our attention that reports that should have been submitted to the commission that sort of tracks officer misconduct were never submitted. We know that those reports date back to at least the prior administration that was in charge of the Kissimmee Police Department.
Is there anything? Many times I've spoken to you all. My administration is not going to turn a blind eye to anyone, whether they are police officers, politicians, regular people in the public, rich, poor, it doesn't matter. Whatever ethnic or religious background, we're not turning a blind eye to wrongdoing in our community.
There was a report of a disturbance, and when Officer Basiglio arrived on scene, and this is all captured on body-worn camera, there were articles of clothing and other items throughout the driveway. At one point, Officer Basiglio actually tells one of his other officers that there's a chance they need to do some sort of mental health check. So they did not take action on his mental health crisis, even though there's evidence that they were aware that one was going on. And then at least one of them proceeded to use excessive force while the other two watched. Mr. Kastner refused to come out of his home, which at that point he had a right to do, and the officers followed him into the home without a warrant, and that's where the use of force occurred. Andrew Basagio went around to the front of Sean Kastner while two other officers, one each, had a hold of his arms behind him, and Andrew Basagio delivered two knee strikes, taking his knee and putting it in Sean Kastner's face, resulting in trauma to Mr. Kastner's face. He was then tased 7 times in his living room. Mr. Kastner was resisting under the law and under KPD policy, but his level of resistance did not come close to warranting the force that was used.
So I want to get this correct for the law, for legal purposes. You are allowed to resist unlawful arrest. So if somebody's unlawfully in your house, like this particular instance where law enforcement was unlawfully in your home, you're allowed to lawfully resist them without violence, which is what happened. So everything that Mr. Kastner did on that night, at that point, was legal underneath the law. And them being inside of his house, putting hands on him, was the problem.
Next, the city of Kissimmee responded. City manager Mike Steigerwald and the new interim police chief, Anzueto, responded to the grand jury findings last week.
Interim Chief Anzueto has been tasked with performing an extensive and comprehensive review of the department with a primary focus on the following areas. First, leadership. He'll be evaluating the command staff knowledge, experience, and skill set to ensure a trustworthy and competent law enforcement professionals lead this department. I want to take this opportunity to reaffirm the City of Kissimmee's commitment to addressing these issues transparently and thoroughly. We recognize the need for change, and today's release of the presentment and the announcement of actions we are already implementing marks a crucial step in that process. The actions that we've taken are not just a response to past failures, but a clear path forward towards restoring trust within our community, and we thank the grand jury for their hard work and their recommendations.
Haven't been able to take my eyes off my husband's pants since he tried this morning trick. What happened afterward was unbelievable. I thought it would be just another quickie. But my husband went hard on me for 2 straight hours after trying a simple secret mixture. It might sound strange, but your wife or girlfriend will thank you for what.
The issues the grand jury identified are deeply troubling, showing errors in former Chief Holland's decision-making, Steigerwald said. It's my responsibility to provide our community with a seasoned leader to detect deficiencies and restore the image. Just need a new hype video. I'd be happy to help them with that. Or they could just use the one I just did.
I've already tasked my staff to implement refresher training on all sworn on crisis management, search and seizure, and investigative procedures. Furthermore, I've already made changes on day 1 to revamp our internal affairs section. Every decision we make and every step we take forward must be grounded in our promise to serve Kissimmee with honesty and professionalism. To our community, I want you to know that we are committing to restoring and earning your trust daily. Together, we can build a department that truly reflects the best of this community and serves as an example of excellence in law enforcement. It's troubling. The video is troubling, but this is day 2 for me. Let me digest everything and implement whatever changes are necessary.
Shocked. Absolutely shocked.
Are knee spikes within department policy?
We'll go to you and then we'll go back to you. Say that again, I'm sorry.
Are knee spikes within department policy? Because I know it happened twice, plus 7 taser cycles.
Yes, knee spikes are a part of our use of force or response to resistance continuum, but to knee spike somebody in the face, there has to be, it has to reach a level where you feel that your life is in danger. And obviously that was not at that point. Do we have some that might not be doing the right things? We're going to learn that in the investigation from the Orange County Sheriff's Office.
He said that resources with Orange County Sheriff lead an inquiry into the 11 officers named in the grand jury report who are alleged to be liars, basically, and who are still at the department with a badge and a gun and might pull you over at any moment and then lie about it. My goals are clear: to equip officers with the resources and training to perform duties safely and effectively, to set and uphold high standards of conduct. Let me help you. Just fire the 11 officers who lied. The grand jury clearly thought that the citizens needed to know who these officers were who were involved in the investigation and mentioned in the report in order to protect themselves and also to hold their government accountable. I have the report. I posted at the blog post on this in the first pinned comment below, so you can read the entire report yourself. It's 35 pages long. It does mention who the police officer witnesses were who were subpoenaed before the grand jury. Anyways, the report has all the names. You can review the report yourself if you have any interaction whatsoever with the Kissimmee Police Department, either now, in the future, or in the past. The craziest thing is that this is, like I said, it could be any one of my videos or any other video on the internet. I mean, these things happen all the time, and it is so common for law enforcement to circle the wagons and to protect their colleagues, the thin blue line, than it is to engage in any actual meaningful search for the truth or enforcement of civil rights. Now, why did this occur here? Was it for political reasons because there's an election happening right now and this particular prosecutor is up for re-election? I don't know. And I don't really care, because this is exactly what should be happening across the country. This is real accountability. It's not perfect, but look what happened. I mean, they're not even done cleaning house. And this didn't require the feds to step in. This was prosecutors in that jurisdiction hauling everybody before a grand jury, and not to cover it up, but to actually search for the truth and deliver accountability.
Well, we should care. I mean, you should care about the quality of the people that are there to protect and serve you. And so that's the whole thing about what we looking for in any public servant, is that are they there to do the job, and they're doing it with integrity, accountability, and are they being transparent about what's going on. And when something does go wrong, because look, things are going to go wrong, are you going to step up and be the person that's going to say, hey, this is wrong, we're going to do something about it, we're going to change what's going on, we're going to identify this thing, and we have to make sure that that's what we're going to do as a community, and as especially in the law enforcement community.
I think this is great what's happened, but there's still more work to do, because there's at least 11 that are still there. There's more house to be cleaned, and you can help with that by sharing this footage. Keep the pressure on and send a message to law enforcement agencies elsewhere that this is what's coming. Either do it yourself, or one way or the other, we're going to do it for you. Let me know in the comments, how do you like Kissimmee's new video that I helped them with? Also subscribe both here and at the blog at thecivilrightslawyer.com, because I'll continue definitely to follow this one. Follow me on Twitter at JohnBryanESQ, also called The Civil Rights Lawyer there. Our rights don't end where your fear begins. Freedom is scary. Deal with it.
Come give the Kissimmee Police Department a chance, and you'll see what's in our heart.
Yeah, it's nuts. Y'all see, this is crazy. Oh, Brady, that's what happened? That is terrible. All right, y'all. I got another video. I wanted to go ahead and watch with y'all. It's been a lot of videos that I've been seeing, but y'all know to be able to stream is a little difficult. Like, even some days it's like, y'all know, it's tough. I appreciate everybody that's here that support me, and Hold on. All right, y'all. We're on Audit channel, and this is titled "Fearless Grandma Stands Up to Corrupt Cops and Wins." Y'all gonna see this one. This one wild.
Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers interfering, pat-downs, and the First Amendment, and is brought to us by Duck to Police's channel and Lackluster's channel. Be sure to check out the description below and give them the credit that they deserve. This will be another double feature episode, so be sure to stick around for our coverage of both of today's interactions. On September 9th, 2024, a deputy with the Montgomery County Precinct 5 Constable's Office in Texas initiated a traffic stop on a driver who pulled into a gas station parking lot. The interaction that followed was captured on the deputy's body camera.
You gonna roll down the window? Why not? Roll down the window.
Yes, can I help you?
Officer Norton, Montgomery County Constable's Precinct 5.
You already know whenever they approach you and they start off speaking like that, you already know it's gonna be a difficult time. Anytime they approach and they come off like this, you already know it's gonna be bad.
The reason I pulled you over is your license plate is obscured. I cannot see your license plate.
You're full of crap anyways because it's got my bicycle things on it.
It still can't be covered.
Yes, it's not covered. It is, but
it's obscured.
Legal.
No, it's not. I cannot see your license plate. I cannot see your license plate.
I'm sorry.
Okay, so it's obscured. Do you have your license on you?
Yes, I do.
Okay.
However, it's not obscured.
Okay, it is obscured.
You can call Officer Simpson, Sergeant Simpson, and ask him. It is not obscured.
So me not being able to see your back license plate, don't roll up your window on me.
Oh, watch me.
Okay.
It's an accident to begin with, so don't threaten me.
I didn't threaten you. I said don't roll.
Don't roll up your window on me. It's an accident to begin with.
Okay, that's all I said was don't roll your window up on me. Where's your license?
It's obscured.
Okay.
That's correct.
We can agree to disagree.
The deputy claims that the driver's license plate is illegally obscured by the bicycle rack, and the driver argues that it is not. Subsection A7 of Section 504.945 of the Texas Transportation Code states that, quote, a person commits an offense if the person attaches to or displays on a motor vehicle a license plate that has a coating, covering, protective substance, or other material that distorts angular visibility or detectability, alters or obscures one half or more of the name of the state in which the vehicle is registered, or alters, covers, or obscures the letters or numbers of the license plate number or the color of the plate. Now, while this could conceivably prohibit covering the letters or numbers of the license plate with a bicycle rack, the statute specifically states that, quote, subsection A7 may not be construed to apply to a bicycle or motorcycle rack that is...
You can't change it and say that it's for something else when you see that it's for bikes. And she has bikes, and it's not like she couldn't see it. It's because you couldn't see it. You had to get closer to look.
Is attached to a vehicle in a normal or customary manner. Accordingly, it is highly probable that a court would conclude that the driver's license plate was not unlawfully obscured, and that therefore the traffic stop was unlawful from its initiation.
Where are you coming from today?
None of your business.
Okay, cool.
Right.
Any weapons in the vehicle?
None of your business.
It is my business, actually.
No, I don't have to answer any more questions.
Yeah, you do. Are there any weapons in the vehicle?
Here you go.
Are there any weapons in the vehicle?
No.
Okay. Any illegal narcotics?
I'm not answering any more questions.
Okay. Cool. Go ahead and hop out of the vehicle for me.
Excuse me?
Hop out of the vehicle.
The fact that she answering your questions the way that she want this lady to tell her everything about her, but where you going? Where you like? it's crazy. Y'all see, this is an insane situation.
Go ahead and hop out of the vehicle.
This is the dirty little secret of adult film stars. I thought it would just be a quickie. But my husband went wild on me for 2 straight hours in bed after trying a simple secret mix. It might sound strange, but your wife or girlfriend will thank you for watching this video. Head to your...
No wife or girlfriend is not, they're not going to be, they wild for these ads. I don't know why.
Say that again. Go ahead and hop out of the vehicle. No. Get out of the vehicle. Out of the vehicle. Yeah, you are.
Oh, no, I am not.
Yes, you are.
No, I'm not.
Yes, you are.
No, I'm not.
8520. Can you send me another unit? I have a occupant that's refusing to get out of the vehicle.
I'm not getting out.
Yes, you are.
Can I get a second 850?
I do not have to answer any questions, and I am not getting out.
It's a lawful order.
No, it's not a lawful order.
Yes, it is. It is a lawful order, me telling you to get out of the vehicle.
I am not getting out.
You can open up the channel. You can get out of the vehicle, or you can go for... We'll sit here and all day. All I asked was for you to get out of the vehicle.
I am not getting out of my vehicle.
I don't know what's in this vehicle. You're not telling me if they're weapons. I asked you if they're weapons. You said, I don't have to tell you.
There's no weapons in my vehicle.
You said, I don't have to tell you.
There's no weapons in my vehicle.
Okay, cool. Well,
So I do not have to get out of my vehicle.
yeah, you do. It's a lawful order.
No, it's not.
Okay, we can agree to disagree.
I'm not doing anything wrong. There is no reason for me to get out of my vehicle, and I gave you my driver's license.
Okay, well, we can either pull you out.
Call Sergeant Simpson.
I don't need to call Sergeant Simpson.
There is no reason for me to get out of my vehicle. I've not done anything wrong.
So me asking you is a lawful order.
No, it is not.
Yes, it is.
It is not.
It definitely is a lawful order. Okay.
It's not a lawful order because there is no reason for it.
Okay, she already locked it.
The deputy threatens to take the driver to jail for interfering, for refusing to get out of his vehicle, arguing that it is a lawful order. As we have discussed many times in ATA, the Supreme Court held in the 1977 case of Pennsylvania versus Mims that a police officer may order the driver of a lawfully stopped car to exit their vehicle as a matter of course. Likewise, courts have held that Texas drivers who refuse a lawful order to exit a vehicle may be arrested for interference with public duties in violation of Section 38.15 of the Texas Penal Code, which states that, quote, a person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. In the 2024 case of Castro versus Corey, the Fifth Circuit Court of Appeals, which has jurisdiction over Texas, held that a driver's, now quoting, repeated refusals to exit his vehicle interfered with a peace officer's duty in violation of Texas Penal Code Section 38.15. However, in reaching this conclusion, the court specifically noted that the district court had determined that the officers involved had reasonable suspicion for the initial stop and seizure of the driver, which, according to the Fifth Circuit, now quoting, confirms that the officers were exercising lawful duty as required by this statute. Additionally, the Fifth Circuit held in the 2007 case of Freeman versus Gore that an individual could not be arrested for a potential violation of the Texas interfering statute for disrupting an unlawful warrantless search of her home. The court concluded that a reasonable officer would have known that they could not lawfully search the home, and that, therefore, the homeowner was not, now quoting, interfering with the exercise of any authority granted to the deputies by law. Consequently, because the traffic stop itself was not lawful, the deputy could not lawfully order the driver out of the vehicle under the Mims case, and a court would therefore likely find that the driver could not lawfully be arrested for interfering, for refusing to exit the vehicle.
That's all right. We got a sergeant on the line right now. You can sit here, or you can comply with our orders.
There is no vehicle. There is no reason for me to get out of my vehicle.
I don't know what's in this vehicle. You were hesitant on me asking if...
Let me stop this right now. Just so y'all know, if y'all don't already know, this officer is completely wrong in this situation. It's the way she's going about everything. It's just, you wouldn't expect this, and you wonder what Why are they hiring people like this? And what training are these people going through to where they feel like they're doing the right thing here?
If there were any weapons in the vehicle and you said no, I don't have to tell you. So
No weapons in my vehicle. If you're not shining your flashlight in my eyes, I'm deaf.
You're deaf?
Well, that has nothing to do with a flashlight in your eyes. Anyways, I'm gonna run her.
Basically, it's like, why use multiple chargers when one charging station does it all? It's a smart, ultra powerful desktop charging station that is made.
It's a very common thing across the country as well. It's not even just our community here.
So, as y'all see, she obviously has bikes and she has a bike rack. And the cops is saying, oh, I can't see your license plate. And it's obscured. When it's very legal for you to have a bike rack and the bike's covering the bike. So unless she goes all the way up to the car, y'all already know this is absolutely ridiculous. What she's trying to make this lady go through for no reason.
Hands on the hood. Anything you don't need that's gonna poke prod me? Pat you down for officer safety.
No.
Hands on the hood.
That's not a pat down. That is to pull my bra.
It is definitely a pat down. We can argue all you want. I don't know why you are being so defensive.
You are not patting me down. You are feeling up under my bra.
Is that I'm allowed to?
The deputy claims that she is allowed to feel under the driver's bra as part of the pat-down, and the driver protests. During a Terry or traffic stop, law enforcement officers are generally allowed to perform a limited pat-down search of a person for weapons if they have reasonable suspicion that the person may be armed and dangerous. As the Supreme
So, by that, how the way that's worded, they're going to use that, whenever they feel like they want to use that. But we know that she wasn't checking her for weapons. And by you pulling up the back of her bra, there's no reason for you to do that to check for a weapon. If she had a weapon, you would know by patting her back. But or y'all know, this is
Court explained in the 1993 case of Minnesota versus Dickerson, quote, "The purpose of this limited search is not to discover evidence of crime, but to allow the officer to pursue his investigation without fear of violence. A protective search must be strictly limited to that which is necessary for the discovery of weapons which might be used to harm the officer or others nearby. If the protective search beyond what is necessary to determine if the suspect is armed, it is no longer valid under Terry, and its fruits will be suppressed. Accordingly, even assuming that the officer had reasonable suspicion for the initial traffic stop, which she did not, and that he had a reasonable belief the driver was armed, which is questionable, a court would likely conclude that the scope of the pat-down exceeded the permissible scope of a Terry stop and frisk. While an officer conducting a lawful pat-down may pat the exterior of clothing near the bra, a court would likely find that the deputy's decision to feel under the bra in this case was more invasive than permitted by Terry, as the level of intrusion appeared to be aimed more at discovering evidence of a crime rather than searching for weapons, especially since the deputy had no specific concealed that area.
No, you're not.
That's okay.
Okay. Anything in the car that you're not supposed to have? Okay. Do you mind if I search the vehicle?
Yes, I do.
Okay. Okay. Stay right there.
And for her to act like this woman is the one causing her problems when it's insane.
Can you make note that the occupant got out of the vehicle? And do we have any canine narcotics available? Huh? Yeah.
Now, y'all, she gonna call.
Yeah, I'm gonna, wonder if it's enough for me to, because technically she was interfering.
Oh, yeah. I'm done it.
I'm gonna call the DA. Did you call the DA before you? Yeah.
So she about to call the DA, and the DA is gonna tell her that what you're doing is all bad. But the DA wasn't firm in telling her that she was wrong. The DA was just basically saying, yeah, we're wrong, you're wrong, but if you feel like doing it, go ahead and do it anyway. That's pretty much what he told her.
What my guy had physically had to remove him out of the car.
All right, I'm gonna call the DA. Hello, it's Officer Norton with Montgomery County Constable's Precinct 5. I got a question for you. So, out on a traffic stop for obscured license plate. She has like bikes covering her license plate. I can't see the license plate. When I told her that I wasn't able to see the rear license plate, she argued with me and says that it's not obscured. I asked her multiple times to get out of the vehicle because when I asked her, sorry, hold on. When I asked if there were any weapons in the vehicle, she said that she didn't have to tell me. And finally, after asking her multiple times, she said, no, there's no weapons in the vehicle. I then asked her, okay, well, do you mind stepping out? That way I know, you know, for my safety, your safety, everything's okay. And then she refused to get out of the vehicle when I asked her multiple times. It took 4 other officers to ask her verbally. We didn't have to physically remove her. As I'm
So she didn't want to get out because really you pulled her over. You pulled her over for nothing and didn't have any basis about the whole stop. But anytime they ask you to get out the car, the best thing to do is just get out the car.
patting her down.
But it doesn't mean they're right about telling you that.
Seeing if she stuffed anything anywhere in her bra. She said that I was not doing a pat down, that I was illegally searching her. So I was going to see if that's enough for interference.
Give me a second. I'm going to look at something.
Okay.
Okay.
Here's where you're at.
I'm with you. Technically, yes, you have the violation if you want to file it.
Yes, if you want to file it. What type of DA is telling an officer this on a traffic stop?
Bad in court. The first one is the statute that I wanted to look at is that bicycles and motorcycle racks attached to a vehicle in normal and customary manner cannot be used as a basis for obstructing a license plate. It's actually spelled out in the statute. Now that's problem number one. Problem number two, she has a valid point about the search in saying that you patting her bra is not a pat down, it's a search. So the long and the short of it is, I would not do it, but if y'all really want to bite off that fight, yes, we'll file it.
No, I mean, I'm going to go with obviously what you say because I'm calling you to get your opinion on it. I was under the impression that if we weren't able to see a plate in the back at all, then it was obscured.
Well, I read you the exact language, and so you can see how you think it applies to your exact facts because you're looking at your situation live. I'm not.
Yeah, no, I got you. Yeah, I mean, I physically can't see the plate, so I legit had to go under the bikes as I'm pulling over the vehicle to see the plate. So
I'm giving you my distance, so yeah, whichever way you want to go, it's fine with me.
Okay. All right. Thank you so much.
Yeah.
All right. Bye.
Why is everyone spiraling over YouTube banning ad blockers? Like, chill, guys. Just use Pi. It's a free Chrome extension that's actually made by.
You know, it's wild that a DA would tell an officer to just do whatever you want, pretty much. It doesn't matter. Well, I'm telling you that you're wrong about it, and you're gonna have problems when it comes to defending yourself in court. But if you want to do it, go ahead and do it. What type of DA is telling this to officers? And you see all the problems that we have to deal with. You can, just this whole thing is just, y'all see, like.
That's there. You can disregard.
Were you wanting to speak with the sergeant, or?
You have any questions? All right. Well, the sergeant's right here if you want to speak to him. If not, you're more than welcome to go on about your day.
Thank you.
Do you have any questions for me, for him? No?
You're welcome to go ahead about your day like you was doing before I pulled you over and wasted your time and stressed you out. All of this stuff. But basically I'm saying, okay, you can go ahead and do what you're doing anyway. What type of...
Oh, okay.
After talking to the DA, the deputy allowed the driver to leave without further incident. Very little information is available about this encounter, and it's unknown if the driver filed a complaint or intends to pursue legal action. Overall, the deputy gets an F for maintaining a rude and unprofessional demeanor throughout the encounter, demonstrating a fundamental misunderstanding of both Texas traffic laws and the Constitution, and repeatedly violating the driver's Fourth Amendment rights. While the Supreme Court has upheld the constitutionality of traffic stops based on so-called reasonable mistakes of law, in this instance, the statute explicitly stated that it did not apply to bike racks, showing that the deputy was simply ignorant of the provisions of the statute that she was attempting to enforce. When the driver attempted to correct her understanding of the law, the deputy responded in a condescending and defiant manner, despite repeatedly being incorrect in her assertions. And while the deputy at least did not attempt to pursue interfering charges against the driver, she also did not apologize for or even appear remotely remorseful about unlawfully detaining her, searching her, and threatening her with arrest. This encounter underscores the critical importance of officers thoroughly understanding the laws they enforce, and highlights how a single misinterpretation of a statute can escalate into multiple constitutional violations. The driver gets an A for demonstrating a strong understanding of her legal rights, vigorously advocating for herself throughout the encounter, and attempting to educate an unknowledgeable deputy. That being said, I do want to generally caution against refusing officer orders to exit vehicles, as the Supreme Court has granted significant discretionary authority.
Oh, so yeah. If they tell you to get out the car, it's the best thing to do is get out the car at that point. But that doesn't mean give up your Fourth Amendment
authority to officers to order drivers and passengers alike out of vehicles during lawful traffic stops. It is important to remember that a driver does not have to have committed an offense for a traffic stop to be lawful. Rather, the stop must be supported by at least reasonable suspicion. As we discussed earlier, reasonable suspicion can be based on a reasonable mistake of the law, as well as a reasonable mistake of fact. Or it could simply be that the driver's vehicle matched the description of a vehicle involved in a crime. Additionally, in determining whether a traffic stop is lawful, courts look at whether there was reasonable suspicion or probable cause for any offense, not just the offense that the officer actually believed was committed. In this case, the traffic stop seemed to be unconstitutional, but it is possible that a court could conclude that it was lawful based on information not available to us. As such, I suggest that citizens always comply with orders to exit vehicles, even when they appear to be unlawful. Let's move on to the next interaction. On August 18th, 2023, Deputy Croft of the McCracken County Sheriff's Office in Kentucky was driving without his lights activated when he allegedly merged across two lanes without using a turn signal, nearly driver Juniper Mulligan, who avoided a collision by slamming on her brakes. Deputy Croft parked in a McDonald's parking lot, as did Ms. Mulligan, and she walked over to Deputy Croft's vehicle and knocked on his window to talk to him about his driving. As a result, Deputy Croft detained Ms. Mulligan and called for backup, and Deputy Crone shortly arrived on the scene. The interaction that followed was captured on Deputy Crone's body camera.
So, pull up. So, lady was driving. The cop almost ran off the road or ran into her, and she goes to where she was going. It just so happened that the cop happened to be there too, and she decides, I'm gonna tell you about your driving, and this is where that ended up.
I went in the car lane over here. I guess I got to come over. Never seen her over there. Of course, I can't say a whole lot on that. She comes up here.
He's a liar. You can already tell he's a liar, and the way he goes about everything is going to be just off. You can tell that just by how he presents himself right now.
She comes beating on my ankle, scares me to death. I had no clue. Jump out, she starts freaking boom, 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 boom. So I hit the recorder, start recording. And she's doing the way she's doing. I mean, she's yelling, screaming, she's disorderly. I think so.
36. Do you have this 23 last name? Negative. Scene 4, got it. Detective ready.
I'll talk to you in a minute, okay?
36, of course, negative.
The first thing that he's supposed to do is identify himself.
Do you have a name?
Do what? I do have a name.
What is the name?
I told you I'll talk to you later.
Of course, negative.
So the contract, we have minutes. That's amazing. I would have say that's amazing.
For the
You really like that? Yeah. Is Mulligan? Quick turn around. Back.
What?
Disorderly conduct and menacing.
Deputy Croft informs Ms. Mulligan that she is under arrest for disorderly conduct and menacing. According to Section 525.060 of the Kentucky Revised Statutes, quote, a person is guilty of disorderly conduct in the second degree when, in a public place and with intent to cause public inconvenience, annoyance, or alarm, or wantonly creating a risk thereof, he engages in fighting or in violent, tumultuous, or threatening behavior, makes unreasonable noise, refuses to obey an official order to disperse issued to maintain public safety in dangerous proximity to a fire, hazard, or other emergency, or creates a hazardous or physically offensive condition by any act that serves no legitimate purpose. Now, even assuming for the sake of argument that Ms. Mulligan made unreasonable noise, the disorderly conduct statute requires that the individual act with intent to cause public inconvenience. Section 525.010 of the Kentucky Revised Statutes defines public as meaning, quote, affecting or likely to affect a substantial group of persons. This means, as the Sixth Circuit Court of Appeals, which has jurisdiction over Kentucky, explained in the 2011 case of Kennedy versus City of Villa Hills, that, now quoting, Kentucky law does not criminalize arguments and noise that disturb only police officers because such conduct does not risk public alarm. Indeed, because the First Amendment requires that police officers tolerate coarse criticism, the Constitution prohibits states from criminalizing conduct that disturbs solely police officers. Similarly, the Sixth Circuit held in the 1997 case of Barrett versus Harrington that, quote, it is evident that the First Amendment right to criticize criticize public officials is well established and supported by ample case law, and that, now quoting again, freedom to criticize public officials and expose their wrongdoing is at the core of First Amendment values, even if the conduct is motivated by personal pique or resentment. As such, it is highly unlikely that a court would conclude Deputy Croft had probable cause to arrest Ms. Mulligan for disorderly conduct. Now, as for a menacing charge, Section 508.050 of the Kentucky Revised Statutes states that, quote, a person is guilty of menacing when he intentionally places another person in reasonable apprehension of imminent physical injury. Now, while it is possible that Deputy Croft was startled by Ms. Mulligan knocking on his window, this conduct almost certainly did not rise to the level of menacing, as there could be no fear of an imminent physical injury given the physical separation between Ms. Mulligan and Deputy Croft. Likewise, any so-called apprehension that Deputy Croft may have experienced could not be reasonable, as knocking on a window is a commonly accepted way of getting a park driver's attention and is not a threat of violence. Finally, it is abundantly clear that Ms. Mulligan was intending to try to speak with Deputy Croft, not place him in fear of imminent injury. As such, it is likely that a court would also conclude that Deputy Croft did not have probable cause to arrest Ms. Mulligan for menacing.
This is funny. Okay.
Don't
I'm going to do it. Okay, don't wrap the hand.
Put your hands behind your back.
You want my keys home? Yeah, take my keys.
Hold up. Don't be reaching anything out of her pocket.
Why?
Back up.
We'll give it to you, but don't be jerking out till we know. We don't know what you're pulling out of your zip.
You know, hey,
Okay, then have a seat. Yeah, actually, we can. You're under arrest.
you're under arrest. Stop it.
Oh, that's my dog.
I'm double locking these cuffs so they don't tighten up on you, okay?
You got any fucking abs, anything on them?
All right, I'm gonna walk you back here, okay?
I would like to give my mother my keys now.
Okay, that question.
I would like to give my mother my keys.
No, so you're not gonna do it. You're handcuffed, okay?
I know.
So,
I want my mother to go in my
listen to me.
No,
You're
I
under
want
arrest.
her
This is a
to take
search incident to arrest, okay? I'm lawfully able to search you after you've been placed under arrest, okay? I understand, but I'm just telling you how it is. Obviously, I was the initial officer who was out here, so I'm going to make sure that he's okay with her having the keys, and if he's okay with it, then that's what we'll do, okay?
Sure.
Just want you to know, okay, I'm actively recording right now, so what I'm going to do is I'm going to search you well enough to ensure that you don't have anything that's going to harm me, okay? Is there going to be anything that's tucked on you that the jail's going to find when the officer searches you?
Could you imagine that? Like, you going to tell somebody about their driving and you end up going to jail for that. And the person who was taking you is the person who actually almost, harmed you. I'm not going to say killed you, but they almost harmed you. It could have been a terrible accident. And you go tell them that they had bad driving and you end up going to jail for that. That's insane.
Nope. Okay, I appreciate the honesty. I think that's everything. Right. I don't know.
Me too. May she have that?
Yeah, we can make a catch. Sure.
And I would like, no, that's my wallet. My wallet is in my back pocket.
Okay. Let's write this up.
Mom?
Check signal this up.
I'll get the
Yeah, same here.
Mom, come take these things from me, please.
Alright, so you do want your mom to have cash, correct?
I want her to have my keys, whatever's in my pockets.
Yes.
I'd like to keep my chapstick though.
Make sure there ain't nothing folded up in here. Alright, is there anything in your back pocket? Right side.
Yeah, there's my wallet.
Your wallet in your back pocket. Can you go ahead and just grab that out with your left hand?
Sure.
No, absolutely not. Okay, yeah, come here. You're on.
I was just near my property.
33 for check welfare.
Space to do. Yeah.
2236 Homewood Avenue.
Take some side steps
Caller
to your
providing
left.
there's a female possible 218A. 218A.
What I'd like to do is I want you to spread your legs, just like this. Okay.
Currently public service right now, saying she's going to harm pets and chickens in the area, unknown weapon. Via shoulder length, hair, black shirt, white shorts with flowers and crocs.
Hey, unless you want to go in cuffs, give me those keys. Stand over there. Stand over there.
or you're going to be arrested for interfering in this investigation. Stand back.
I'm just got her keys.
You're not grabbing anything on this car. Stay there. Do not touch the keys.
Excuse me. I'm not a freaking dog.
I have a wand right here. This is a metal detector. Okay. Okay, spread your legs back. I want you to turn around and face me. I'll take your hat off. Hold for that AC. Good. Yeah, I don't know why they're doing this today, but we're good.
Woo! Woo! This is the beast of all beasts.
I'm going to read you something because you're currently placed under arrest, okay? You have the right to remain silent. Anything you say can and will be used against you in court. You have the right to an attorney before making any statements and have your attorney with you during questioning. If you cannot afford an attorney and desire one, the court will appoint one for you. You may stop the questioning at any time by refusing to answer further or by requesting to consult with your attorney. Do you understand each of these rights that I've explained to you?
Yes.
Okay. Keeping these rights in mind, you know you don't have to talk to me and you can invoke these at any time.
All right.
Do you wish to talk to me about what happened today?
Yeah, once they reach you that, you shouldn't say nothing to them about anything.
That led to this? Because it's honestly, I don't know. I rolled up here and
It's honestly, I don't know. All that's BS. After they reach you that, don't say nothing. It's nothing to talk about.
the situation was already happening.
All right. Will it affect my arrest?
Do what?
And she said, will it affect her arrest?
What?
Will it affect this? Do I get out?
No.
No, it won't help you get out. So it won't help you get out of the situation that you're in. So it's at this point, I wouldn't say nothing.
Okay, well, that cop car had across 2 lanes of traffic.
We're at over here on the road.
On the bridge. Right in front of me, across 2 lanes of traffic, no lights, no signals. And I honked at him, and then I came here to tell him he was a bad driver, and this happened.
Tell me how you went about telling him that he was a bad driver. I believe that's where the problem's going to lie.
I knocked twice on glass. That's it.
We could have went about this in a better way. You know that you can just go to the sheriff's department and say, hey, I want to talk with the sheriff. I've got a problem with what happened today on the road. Do you realize that's the way to go about this? Because personally, let me tell you something. I do not enjoy taking away people's freedoms. I did not get in this job to do so. And I hate that this is what it's come to today, okay? But I wish that on your side as well, I wish that we could have done better today.
All I was going to do was let him know he could have crossed 2 lanes of traffic. You know, if you're supposed to uphold the law, you should actually follow the law.
I agree.
You should be aware of the laws he's trying to enforce.
Well, let me ask you this. Would you think if we could go back in time?
If you agree with what she is saying, why is she in the back of a police car with handcuffs on and you just read her rights because she's under arrest? If you agree with her, you know, that makes no sense. Because if he actually cared about the law and cared about what's right or wrong, she wouldn't be in the back of a car right now.
It's a little bit different. You think that it was appropriate. But I tell you, whenever you go there and you beat on his window and you put him in fear of physical injury.
Okay, I disagree with that.
Well, I wasn't here for that, okay? I appreciate you.
He was in fear of physical injury. Look at her. Like, what's wrong with you, man? How scary are you? Imagine somebody. Imagine a man in this situation.
You're nice and cordial with me and talking to me. I promise I'm not a mean person. Okay. I'm gonna do my best to be able to have your mom take the car where it doesn't get towed. Okay?
I appreciate that.
Fine. I'll be back with you this morning. Okay? Can you feel the air?
Yes.
Okay.
After reading Ms. Mulligan her Miranda rights, Deputy Crone questions her about the incident. As we have discussed before here on ATA, the Supreme Court held in the landmark 1966 decision of Miranda versus Arizona that officers must inform suspects of specific details regarding their legal rights under the Fifth and Sixth Amendment before they can subject them to so-called in-custody interrogation. Although the initiation of a formal arrest will generally render a suspect in custody for the purposes of a Miranda analysis, courts have also found that Miranda warnings are required in some situations where a citizen is in custody but not formally under arrest. As the Supreme Court explained in the 1995 case of Thompson versus Cohane, quote, two discrete inquiries are essential to the determination. First, what were the circumstances surrounding the interrogation? And second, given those circumstances, would a reasonable person have felt he or she was not at liberty to terminate the interrogation and leave? Now, in this situation, Ms. Mulligan had been formally arrested, handcuffed, and placed in the backseat of a police vehicle, so it is virtually inarguable that she was in custody and that were required to interrogate. However, there are circumstances where Miranda is implicated even if a formal arrest has not been conducted. Conversely, courts have also determined that who are placed into the back of police vehicles are not always considered to be in custody for Miranda purposes. As the Sixth Circuit Court of Appeals explained in the 2007 case of the United States versus Wright, quote, merely placing an individual in a police car does not automatically transform a Terry stop into a formal arrest. Instead, we look at the totality of the circumstances, focusing on the purpose of the questioning, whether the place of the question was hostile, coercive, the length of the question, and other leave or to request the officers to do so, whether the suspect possessed unrestrained freedom of movement during questioning, and whether the suspect initiated contact with the police. Therefore, even though Ms. Mulligan was almost certainly in custody at the time of this interrogation, there may be situations where officers are not required to give Miranda warnings prior to questioning citizens that they have placed in police vehicles.
Yeah, I'll open the window. She can talk to you. Would you like to come speak with her? You can talk to her, say whatever you'd like. I just ask that you don't reach in there or take anything. Just talk, okay?
What? Let's go have my chopstick. Here's some tea. How you doing, hon?
Could be better.
Like I said, I searched you. You're a woman, so I'm not going. I searched you well enough to make sure that you don't have any knives, guns, or anything that can hurt me. Okay? The chapstick that's in your pocket, you can just leave it there. Okay? It's okay.
Let me know the incidentals.
You'll just probably ROR right out. Okay?
Probably what?
You'll probably just ROR right out.
I don't know what that is.
They're basically going to go up there, they're going to take your information, and they're going to release you on your own recognizance to come back to a court date. So
I have no way home. I've got 7 animals I got to take care of.
all right. I'll make sure I let them know. I think we're going to be able to do that. So, but I've got to go over there and talk to them, so I'm rolling the window up. So just kind of hang back over there in the shade. Do you want this with mom or not?
Yeah, she can have it.
Okay. Real quick.
Well, once they turn off the audio, you know that was for a reason, and this whole situation is corrupt and everything about this is wrong. Whenever they hit mute or they turn off their body cam or anything like that, you already know that what they're doing is wrong.
Your mom. I don't think that it was a good idea of what daughter did today.
I
Just
know
like I was
that.
telling you, just like I was telling her. And she even said, she'd go about it different. I'm gonna put your seatbelt on you. Just go straight down, okay? Are those cuffs okay on you right now?
They're not really comfortable.
Well, they're not designed to be comfortable, but is your hands okay right now? They're not like numbing out or anything?
No.
All right, well, we ain't got that long. It's just a little short. Oh, there it goes. All right, we're gonna go up there.
Ms. Mulligan was transported to a county jail where she spent the night before being released. Ms. Mulligan alleges that during her time in jail, she was forced to sleep on the floor of a crowded room, and that a jailer found a snake in the building and brought it to her cell to show the detainees. Ms. Mulligan fought the charges against her, and they were eventually dismissed. Ms. Mulligan also expressed serious concerns regarding inappropriate sexual advances and the mental health of the public defender assigned to her case. These allegations are discussed in detail in Lackluster's coverage of this encounter, which I've linked in the description down below. The charges were expunged in December of 2023, and Ms. Mulligan filed complaints with the jail and the McCracken County Sheriff, the results of which are unknown. Ms. Mulligan also filed a lawsuit, and the case was settled for $25,000, $5,000 of which Ms. Mulligan donated to a domestic violence crisis center. Overall, Deputy Croft and Deputy Crone get an F for arresting Ms. Mulligan without any legitimate cause to do so and demonstrating a clear deficiency of knowledge regarding Kentucky criminal law and the Constitution. Deputy Croft also maintained a belligerent and unprofessional demeanor throughout the encounter. And while Deputy
They lucky it was only $25K, and that's probably because they didn't take it further than it needed to go, and they offered her 25, and she probably said, "I'll go ahead and take that," but could have been. We already know that everything about this was wrong.
Crone did behave more politely. He not only completed the unlawful arrest of Ms. Mulligan, but repeatedly scolded her for simply trying to approach a police officer in public to voice her concerns. It is not illegal to knock on a police officer's window, as any reasonable officer would clearly understand. And it seems that this arrest was yet another instance of the infamous offense of contempt of cop. Ms. Mulligan gets an A for attempting to confront Deputy Croft about his dangerous driving behavior, maintaining a relatively calm and respectful demeanor throughout the interaction, and complying with the arrest and challenging its validity after the fact. Ms. Mulligan's conduct during her blatantly unlawful arrest is an excellent example of how citizens should behave when they are unconstitutionally arrested, particularly in states like Kentucky, where citizens can be convicted of resisting an unlawful arrest. And although I would have preferred to see Ms. Mulligan invoke her Fifth Amendment rights when Deputy Crone interrogated her, she did not admit to anything incriminating because she had not committed any crimes. On the whole, Ms. Mulligan did an excellent job balancing compliance and verbal dissent, and I applaud her for fighting the criminal charges against her and taking appropriate civil legal action to hold the deputies involved accountable. Let us know if there's an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for
All right, y'all. All right, I'm gonna go ahead and end this stream. I appreciate everybody for joining me and watching these videos with me. And if you can, go ahead and grab my book off Amazon, Eyes on Authority, How to Hold Public Servants Accountable from the Streets to the Screen, documenting the fight for freedom. So it's basically, this book pretty much is about the First Amendment and continuing to make sure that you are exercising your rights. You got to know that if you don't exercise your rights, they're likely to walk all over them. So With that being said, AWB, I'm out.